Hello. Oh, okay, there we go. I think that's a little better. Hey there, hope everyone is well. When you get to see this, decided to come live. One of the things that I want to do more regularly is the Trademark Tuesday because I do get a lot of questions because I do trademarks. Since I do get a lot of questions, I am going to just trying to get to my notes so I can make sure that I don't miss anything. I just wanna make it a regular series, and also, I think this is a great time to come in and ask questions of any sort that you have, but particularly about trademarks. The format is that I will typically have a question of some sort that has been asked of me in my dealings with clients. So, I thought that would be the most practical use of how to get information out. So today I was just reading up on a wait, I guess I gotta back up. I usually think that everyone knows me. I think the last Trademark Tuesday I did, it's been a little while, but excuse me. Again, I am Tanisha Molden, and I am the host here in the Intentional Wealth Project. But also, I am an IP attorney and brand strategist, founder of Molden Law and Generation Squared. Can't wait to share more things about what's coming out with with you guys. So every Tuesday, or at least almost every Tuesday, I really would like to break down what happens in some of my talks with clients, what you need to know to protect your brand and build something that you actually own, because that is I guess my creed, or what I think is really important is ownership. And what we're getting into today is I see that messes some people up a lot, and I'll share a story that totally with a popular brand that they're in a litigation now about. It's not necessarily because they're careless, it's because nobody may have told them when it comes to smaller brands, and that is regarding clearance searches. And I had a conversation with a brand business owner yesterday about a clearance search and why it's important and why it matters before you launch anything, if at all possible. But also, I know it's also on the way to launching your product, your a name, any extension of any sort, almost anything. If you're thinking about growing your brand, a clearance search is important, and I'll get into what that is. And so, what I'll do is pull some lessons from a brand new lawsuit that was filed in March 2026, and this involved Taylor Swift. So stay with me. I may have a lot of information, but it's all good information. So I really want to start from the beginning. So what is a clearance search and why does it matter before you launch? Why is it, I guess I would say it was such a big deal. At least attorneys make it a big deal. Why is it such a big deal? Why am I making it a big deal? And why is it the first step in the trademark process? The clearance search is the first step. Now, so a clearance search is the due diligence that is done before you commit to the name, tagline, a logo, or like any of your brand elements, any parts of your mark. You're checking whether someone already owns the rights to something similar that may conflict with yours. Think about it as like the title search on a home. You don't buy the house without checking to see who else has claim on it, right? So you shouldn't launch a brand without doing the same thing. This is what you are checking for, and this is what we check for in our clearance searches. The USPTO database, any federal registrations that are already out there, any pending applications, right? Common law rights, then similar marks that are related to your industry. So, like in the pending applications, of course, in the federal registration, we are looking for anything similar, and that's pretty basic. And I think that's where most entrepreneurs start that I talk with. I've talked to several the past weeks. They say they've done their own search. And when I ask where have they searched, they say the USPTO database. It stops there. Comprehensive search goes much deeper. We'll get into why. So, of course, that is the first step. You start at the federal level, but the pending applications that's also there, that matters because that marks that have not applied These are the marks that have applied but are not yet registered, but they may be on their way. So you want to be aware of that. If you tend to file an application, your application will not get approved if because they filed before you. Because remember, we're in a first to file system. So again, the common law rights, these are the marks that people are using even without registration. So you don't have to register your mark to have rights and you have protections. So you have to be aware of that. This is also what should be included in your comprehensive search. Any similar marks, anything similar in a related industry, because it could cause confusion. And we don't want that. We don't want confusion because it just dilutes your brand and basically dilutes revenue, right? So if someone already has rights to a similar mark, you could be forced to rebrand after you've already started building with a brand. You could put in equity while you're using it. And if you have to rebrand, that's expensive and could be very disruptive to your brand. And it is avoidable. So, what I want to share with you was the recent article I just read regarding Taylor Swift. If you don't know Taylor Swift brand, her brand is extremely powerful when it comes to her trademarks, her intellectual property, and they are on it. But in the sense, they are actually being sued over a trademark. And I'm going to break that down for you now. So, in the case that was recently filed in 2026, this was done, as you believe, in the Central District of California. So, a Las Vegas performer, I believe her name was Maureen Flag, who performs professionally. She has sued Taylor Swift and Taylor Swift's affiliate entities. And here's why. This is really the real core. Maureen uses the confessions of a showgirl, and she says that she's used that since 2014 for live performances and her media. She has a registered mark for that. But Taylor's team has applied for the life of a showgirl for merchandise. And during the application process of the life of a showgirl, the USPTO actually issued an office action. In that office action, they refused registration in part because of likelihood of confusion with Maureen's mark, her existing mark. So it was denied. So why is there a lawsuit now then? Here's where it gets legal. Here's the legality of it, the significance of it. Instead of resolving the conflict, this is Taylor's team. They suspended the application and continued using the life of a showgirl on the album and merchandise anyway. That could be a no-no. So now the USPTO refusal is being used as evidence in the lawsuit. This is essentially saying that Taylor's brand had notice of the conflict and they moved forward anyway. The key takeaway from this, an office action isn't really just paperwork or a hurdle that we have to get by, but it can become evidence against you if you ignore it and keep going forward on infringing on someone's brand, which is the case here. I think what we can take from this, I always like to look at these brands as popular or as big as Taylor's brand is, and how we can utilize the steps, the strategy that they're taking and apply it to smaller brands like ours. And it really isn't just a celebrity problem to put that together. So I know that most people may think that I'm not Taylor Swift, so that doesn't really apply to small business, but it does. And to take that under consideration. That's why I started off with the comprehensive search. This is where I think where it comes into play. And I don't know how the search went, obviously, with the attorneys that work on Taylor's brand. But this is the point that you can take away from that. So under the Layman Act, and that is a federal trademark law, the party with the strongest claim in a trademark is usually the earliest user, not the most famous. So, not the one with the biggest platform, the one who used it first and can prove it. Key point, can prove it. So, what that means is this: if you are a small business owner who has been using a name since 2021 and a celebrity or a larger brand comes in, starts using something similar in 2024, you may actually be the one with the stronger claim. And I think that's really powerful for us to know, but it only works if you protect it yourself. If you've done the clearance work plus registering your mark, because without that, you can't enforce your rights. You have no rights to enforce if you don't take those steps. So the flip side is equally true. If you skip the clearance search and accidentally step on someone else's mark, it doesn't matter how small you are, you can still be sued. And a smaller business has less capacity to absorb like the cost of litigation, or what could happen is you could be forced to rebrand. So that is obviously something you need to be made aware of. Clearance searches are so important. So what happens if you skip this step? If you skip the clearance step? We're gonna go through it. I think there was an earlier case where there was another lawsuit. I think it was Evermore Park sued Taylor Swift too over Evermore album. And that case got dismissed, but it got dismissed quickly for legal terms. But that still meant there were legal fees. So there was public attention and there was reputation disruption, all of the distraction. But at the same time, you still have to go about what you need to do to protect your mark. All I'm saying is that it was probably short lived, but it wasn't cost free. So now if you took that situation and multiply the ones that don't resolve fast, here's the here's what I think what reactive looks like when you didn't do the work up front versus being proactive to reactive. You risk rebranding, inventory write-offs, you risk revising marketing materials, legal fees, loss of goodwill. First one, the rebranding, new name, new logo, new everything. And we know that can be costly, especially if you have it across multiple platforms and assets and products and services. Inventory write-offs, if you have physical products, if your products have a brand that you have to rebrand and relabel, that could be costly, especially for a small business. Revise marketing materials across all the marketing platforms that you're using. And another cost, legal fees, because you have to defend yourself. Settlement negotiations. And if it gets to the point of litigation, the legal fees of defense, cease and desist letters, then settlement and litigation, those fees can obviously add up. Loss of goodwill and your brand equity that you've already built, because you built that brand equity in the brand that you have to rebrand. I think that one may be even though goodwill is an intangible, it is one of the hardest ones for growth stage founders, because you may have spent months, definitely months, if not years, building your recognition around your name. Then you have to start over. That's not just in money, that is the momentum that you built up, and that does take time. So what do we do? Here's what we do. A clearance search. Proper filing. A proper clearance search is like a fraction of the cost to get done. So that investment is the protection before the problem, and not covering damage, not doing damage control. So being proactive, like with almost anything in life, when you're proactive, the cost is small versus being reactive. And I think that is important because that's one of the first steps we take when we're working with our founders. So what do I tell clients to do with doing the first step on trademarks? Do a clearance search before you fall in love with name. Before you design, or as you're designing the logo, if you've settled on one, do the clearance search. Don't you want to be confident going out into the world and using what you use? I think it just feels a sense of confidence that you have this, and also you have the proofs that you are using it first. So if the next step is filing that trademark, you have that and you're confident in moving forward. If you're building websites, that's important. Before you print anything, do the search first. Don't rely on a basic Google search or the USPTO name search. A proper comprehensive clearance search looks at the federal registration, pending applications, common law. It requires trained eyes to see things that you business owners may not be aware of because you're not doing this every day. And then the last, of course, I would say if the search is clear and we have a likelihood to go, great, highly likely that we can get this approved, then I say file the registration if we can. A clearance search tells you that there is a clear path. The registration is how you claim your spot on it. Rights you haven't registered are rights you can't fully enforce. You may have protections, but you can't fully enforce it with the trademark registration. You have full enforcement. So if you really are sitting on a name right now, if you haven't cleared or registered, that's where we start. So if you have any questions about that, what I would recommend is you send me a message, DM me. We can book a strategy call to go through what that looks like. All right, so I am going to close us out. That is our Trademark Tuesday for this week. Let me know what lesson that you've gotten from Taylor Swift's friend, from being a founder, aha moments, if any, that you've gotten for this. And I know that you are working really hard to build your brand. You don't want to lose it over something that can be preventable. We want to be proactive in your business. I could pause there. So you want to be proactive in your business. Again, if you have any questions, drop the questions down in the comments. And most importantly, share this with a founder who needs it. And I will see you next Tuesday.